I asked to be able to introduce myself because I am actually approaching legal Englishes from another perspective than what you might expect. Now, some of you have been in a course that I recently gave over here, but most of you weren't. So let me just tell you what I do in life. I'm not a lawyer. I'm a linguist. I'm a social linguist. And a social linguist is somebody who works on the way languages affect people in society, the way people perceive each other through language, and the way languages relate to each other, of course. And it's our job as social linguists. There aren't too many of us. It's not a bad thing for this world, but you need some. It's our job as social linguists to actually find ways in which you can include as many possible people in a society through language. Now, what has that got to do with law? You could say not that much, but at the same time, law is our tool to create a society in which everybody feels safe, feels present, feels recognized, etc., etc. So based on these principles, we look for solutions. Now, what I'm going to try to do today with you, and I stress the word try, because I don't have all the answers, you have a lot of answers as well, is do a mental exercise in which we're first going to look at what kinds of legal English do we have? What is legal English actually about? Because I understood that there is a discussion going on legal English. That's why I got flown in, I think, to give this talk. So then we're going to look at how you can translate law. How can you look at the characteristics of legal English? What are you going to do then with it, and how are you going to work with translators if you want to work with legal English, because sometimes it's a little bit awkward to do that all by yourself. And then we are going to look at actually the emergence of a new legal language, which is St. Maarten legal English. We do research and advice on language situations. If you want to know what my work background is, I work for the University of Aruba. I also teach at the University of Utrecht, the University of Amsterdam, and the University of Antwerp. And what I teach mostly is social linguistics or legal skills for legal professionals. For the rest, I'm working on socio-economic development and language, of course, which is what we're going to try to do our exercise about tonight. Now, the first question you have to ask yourselves is about what are we actually talking? You are facing an issue in St. Maarten where there's a discussion going on about the question of what are we going to do with English in our legal system. Now, if you talk about languages, you have quite a variety of approaches to that. First of all, you know that there are standard and non-standard varieties of English. Being from St. Maarten, you probably know the St. Maarten variety. Being from Aruba, I know the St. Nicholas variety. Having grown up in Belgium, there were a lot of Brits coming over there. They've got a different accent, you know. And so there are a lot of varieties there. And when we're talking about legal Englishes, then you get even more varieties. You have all those varieties of English, and actually in St. Maarten we're also talking about a specific kind of legal English, because we're talking about a legal English in a national multilingual context. We're talking about a context in which you have Dutch as a legal language and you have English as an emerging legal language, which actually are two languages attached to one legal system. That's something you have to bear in mind. I'll come back to that later. Another variety is, of course, legal English in a national monolingual context. Think about the US. It's hard to think about Great Britain when you're talking about this, because the Scots actually have their own legal English in a different variety. And actually, I think the only state that really has a monolingual system like that is the US. And then you have legal English, of course, from an approach of a comparative multilingual, multinational context. When we're working, for example, in the Netherlands, many of you have been studying in the Netherlands, and when you're talking about legal English and you're having courses in legal English, people will approach it from a completely different angle, because they will be teaching you other legal systems, because Dutch does not have its own English legal system, of course. And then you have legal English in a mono and multilingual international context, and then I'm referring, for example, to the European Union, where you have 24 languages Last time I said 23, but apparently in 2013 Croatian got added to it, so it's 24 now. And that's another variety of legal English, and it's all in different kinds of context. Was this story about varieties of English, varieties of legal English, in which the context in which it is being used dictates what kind of a language you're actually using. So if you have a term in Great Britain, let's say marriage. You all know about marriage, right? So most of you do. Being married in Great Britain is different from being married in the US, which is different again from being married in St. Maarten. I'm not talking about what man and woman have as a sense of being together, but the legal definition is often different, because property rights, the way you can enter a marriage, the way you can finish a marriage, don't think about that, it all is different. So using the same word doesn't always help, of course. Some simple concepts that we think to be the same are not actually. Now, what kind of Englishes do we have in St. Maarten? We have, of course, a lot of non-standard English. We are aware of that, and we also do have standard English. Well, it doesn't exist actually, but anyhow. But we don't have legal English in a national monolingual context. You cannot say that St. Maarten is monolingual. We do have legal English in a national multilingual context, and we have legal English in comparative multilingual multinational context. You have to think about, for example, contract law in this one, where a lot of people in St. Maarten, of course, are doing business with the US, with other English-speaking islands, and this will influence the way, of course, that you'll have contracts upon which American law is applicable, or Barbadian law, or whatever. And you really want to interpret what it is saying over there if you're working with those texts. In those cases, you need kind of a complex approach to what the English language actually means, because you have to understand the other legal system in order to understand what the contract may mean. And then we have legal English in a multilingual international context, because, of course, St. Maarten is part of the Kingdom of the Netherlands, and St. Maarten is very strongly affiliated with the European Union, and St. Maarten, of course, has ties with the United Nations, with the CARICOM, etc., etc., etc. So these are the international contexts in which we also have legal English. All these different kinds of legal English, it beeps, all these different kinds of legal English have other terminology, other interpretation frameworks. That doesn't make life easy if you're talking about legal English. And that's I think one of the reasons why in St. Maarten we are getting into a discussion about legal English, what we want to do with it, what we can do with it, but maybe we're not talking about the same thing. We're not maybe talking on the same level or with the same ideas about what we're actually tackling. I'm going to take you through a couple of steps in that respect, and I hope by the end that I can have given you a framework by which you can help find the answer for yourselves, or maybe I even have a couple of suggestions that can help you in that. First of all, you have to realize that doing translation work is not easy. It's a famous sentence when people teach people to translate, that a boss will tell his secretary, "Please go and translate this for me. It's only 6 pages. I need it by tomorrow morning." Now, translating 6 pages of text is a big job. Translation agencies do overnight translations, but they need teams of translators to do that, and they'll all work the whole night to get it done. Please don't ask your secretary to do such a translation overnight. It's not nice to do that. So, what are those challenges in translation actually about? First of all, of course, you talk about vocabulary issues. One word in one language doesn't mean the same as a word in another language. Take the Dutch word gezellig. You know that one? Try to translate it. Cozy, maybe, but not. Comfortable, maybe, but not. It's just a word that you actually cannot translate. It's a different kind of concept, and it doesn't occur in other languages. It's also in grammar, of course. Word order is different in English and in Dutch, for example. You all know that. But word order also dictates meaning. just having the content of the words is not enough to interpret a sentence. If I say, daar is de deur, that could have a couple of different meanings. Right? You also have interpretational issues in the sense that many words have different meanings. Yes, ambiguity in word meaning. So that, I'm not going to delve into that one, it would take us too long. Then that's one thing, the vocabulary, grammar and interpretation. A second level of challenges is the interpretation itself in the sense of word, sentence, text and discourse in context. A sentence, and I'm really going to focus on the last two ones, actually the last three. A sentence within a text can have a specific meaning. Now, but often these sentences relate to the wider context in which something is happening. If one makes a remark, I'm living in Aruba right now, well, for the past 15 years, and Aruba is going green. Yes, everything is about green Aruba, and we have a whole campaign set up, and we even win awards with it nowadays. And if you think about that concept 10 years ago, and you would have slipped a sentence in a text that was saying something about, okay, we need more solar panels and we're going green, it had like a global meaning that everybody was agreeing on, yes, this is what we're doing now. If you slip in that same sentence nowadays, it has a completely different and even political meaning because it's a political issue now. So that being a political issue now changes the interpretation of what it actually means. It would need a footnote in history to explain this. And then discourse in context in itself, people develop their own kind of discourse. We have traditions that we talk by, that we work with. We have traditions that the way we address each other. If you're meeting a buddy in the street and you'll say, hey there, how you doing? You're good? Yeah, okay. We're happy about it. No problem. But if you meet that same buddy in a formal setting, for example, and this person has the role of being a director of a company, all of a sudden it will be sir and mister and everything and a last name basis. This kind of interpretation in context is very important in a discussion about legal English as well, because sometimes you really have to be aware of the culture of the legal system. You all know about Great Britain and the wigs. Yes, judges and barristers wearing wigs. You know about Kenya and the wigs, they also wear wigs. And it's in South Africa, there's a completely different tradition, but it's all about the suit you're wearing and the color of the suit. So there's all that kinds of stuff that is ingrained in those systems. Then there's another specific issue, another challenge, and that is the use of content-specific language. If you are an engineer, you have another vocabulary than when you're a medical doctor. If you are a lawyer, you'll have another vocabulary than somebody who's a teacher. And people use different abbreviations, people use different insights to frame certain ideas. So you have content-specific language. And then in legal English, we have another issue. We also have content-specific systems. Legal English exists in Great Britain. It exists in the European Union. It exists in the US. It exists in St. Maarten. But they're all different languages. Every legal system has its own legal language. To give you another example to make you understand what I'm saying is, for example, if you have Flanders and the Netherlands, everybody is familiar with these two concepts. You know about the Netherlands, I know, but some people don't know about Flanders. Flanders, north of Belgium, is Dutch speaking. Dus als je het een beetje gewoon zet, dan is het niet erg, want die mensen die spreken met zo'n accent. I grew up there. And Flanders, Belgium, has its own legal Dutch. There are varieties of legal Dutch. You have the Flemish version and you have the Dutch version. And you have the European Union version. And yeah, well, it's difficult to say. And you have the St. Maarten version, the Aruban version, the Curaçaoan version. These are all content-specific systems with their own legal language. So you're not talking about translating between these systems, actually, because we think we understand each other, but practice has shown in the past that we don't always interpret the same terminology in the same way. Let's have a look a little bit further down the road. In the international context, you can say, that's what I was framing just a second ago, that within a language there are as many legal languages as there are legal systems using this language. So for Dutch we have Koninkrijks-Nederlands, Vlaams-Nederlands, Vlaams Juridisch Nederlands, Nederlands-Nederlands. We have like the Arubans and Maarten, Suriname, Kingdom language. Best Islands have their own terminology nowadays. So we're already at 9 legal Dutches. Actually, that should be an interesting topic for a talk as well. What do we do with that? How do we interpret between those ideas? But so there are different kinds of legal Dutch, as well as there are a lot of legal systems using English, of course. So when we're talking about interpretation, it's very difficult when we're going to use English terminology if we don't know where it's coming from. You need to know which terminology you're using, for what purposes, and what goals you want to achieve with using those words. So it says over there, and it's a truism, but legal information has to be translated from one legal language into another legal language. You cannot just say, let's translate using Google Translate, Euroglot, or whatsoever, and just use the terminology. I'll show you a couple of examples of that later on. There are a couple of things that you have to know about legal language, and you've already heard those, so I'll go through them very fast. Or you know it, simply. There is this continuous reproach to lawyers, to legal professionals, that the language used is too complex. It should be flawless. Yes, it should. A contract shouldn't contain errors. It should be unambiguous, of course. But sometimes you also get the impression that lawyers really write in order for you not to understand what they're saying. I see people nodding now. And that's the impenetrable aspect. And it comes through complex syntax, redundant formulations, complex use of words, so you use terminology that people are not familiarized with. And that is an issue. And we also have a tendency of saying, well, actually, the order in which lawyers write, legal professionals write, does have nothing to do with literature. It's not nice to read often. It's not composed in a way that our mind will digest what is being said. So that makes it quite complex to deal with another language in another system, of course. And apart from that, there is some kind of respect for historical tradition, of course, ritual that you use, and you see that in the phrasings of letters, both in legal English as in legal Dutch, that people have a tendency to use ritualistic phrasings that are familiar in those circumstances, but only in those. There is an inventory of these aspects. It's not blocking. No. There's an inventory that's made by Tiersma in 1999, and it's just familiar, common knowledge. We have technical vocabulary. We have archaic, formal, and unusual words. Here on fort, herewith, etc., etc. Use of impersonal constructions. You don't name people, but you call them defendant and so on, or plaintiff, etc. Overuse of normalizations, so you use nouns instead of verbs. And passives, you know, when you can hit somebody, but you can also be hit by somebody. Well, instead of using the active voice, lawyers will use a passive voice. A lot of use of modal verbs that are shall, might, could, should, would, ought to, etc. To give you an example, in 2006 there was a court hearing in Indonesia on the F-16 trade deal between the Netherlands and Indonesia. They bought some of the old F-16s, and the Netherlands were going to lose about $6 million over the interpretation of the word might. And so there was a whole court case only about that. The other problem was that in Indonesia you cannot do a contract that is not in Bahasa Indonesia, so that was another issue, of course. But the problem was really on that one word, at $6 million. So you could get into trouble using the wrong modal verbs. Multiple negation. It is not uncommon. so it is common, you know. Long and complex sentences, you know that, and poor organization of the texts. Now, a very simple, it even changed font during this. A very simple example is this one. This is just an exclusion of intellectual property rights. Sorry, all rights reserved, and then it's. I think it should be over. Right, all rights reserved is enough. That's clear to me. But then if you're in the stage, you should follow up with no part of this publication may be reproduced, stored in a retrieval system, or transmitted in any form or by any means, electronic, mechanical, photocopying, recording, or otherwise, without the prior permission of the publishers. I always think the funny part is in or otherwise, because you could have said it at the beginning, in any way. Yeah? Done. But we really want to put in as much as possible. That's also because many lawyers think they get paid by the word. So if you use stock phrases, I know you're not, but many people use stock phrases because they just fit in very easily. Another example, a release given by one party to the other, and a civil lawyer would do a very simple thing with it. A hereby gives full and final release to B. A, put in a name, B, put in a name. Both parties in the civil system know what to expect, know what to understand. Now you go to the case law system, and then it becomes a little bit more complicated. You don't have to read all this, but you can see that it's more than the simple release in which it says A release gives full release to B. It's just a little bit overdone. An attempt to reformulate. I see you frowning. Don't try to read it all. It's just an example of the way in which, in the common law system, in the English law system, contracts, exemptions, etc. are formulated. A last one, in this respect, there is a campaign for plain English. And this is a very simple sentence. This is taken from a court case, but I think it's a joke. The judge who says the charge here is theft of frozen chickens, are you the defendant? And the defendant says, no, sir, I am the guy who stole the chickens. It's just an example to show you that even words like defendant, etc., are simply difficult for people to understand, to grasp. Yeah, and then you get this. This is the last example. I'm not going to bother you anymore with this kind of examples, but this is just a pre-negotiation agreements clause that you also used in the cause, which is also, it's actually saying we're not going to agree on anything yet. Let's agree on that. But then you can do it. Yes, notwithstanding any terms or provisions contained herein, this document does not constitute an enforceable agreement, including an agreement to continue negotiations. So yes, we're going to sit at the table together, but we're not saying that we're going to do anything that has a binding effect. But you see that the wording is a little bit awkward. It's not the way you would speak, of course. Yes, and the words used are awkward for people in normal street life. Now, so if you want to translate this kind of stories, because they start to resemble a story like this, you need special skills and you need to have special knowledge. You cannot just do it like that. Now, I know you're all here because you're interested in what is going to happen in St. Maarten. I'm not going to tell you that, but I can tell you that if you want to translate text like this, try not to be on your own. Try not to be alone in this adventure, because you will need extra expertise, extra input. You will need somebody who reads along with you and who's going to agree with you on how you're going to translate this. Professional translators who translate clauses like this, they end up with completely different texts. Many professional translators actually have no knowledge of the source or target legal system, and they will provide you with a translation that is functionally not helping you. So you also have to look at the functionality, of course. But then, if you're looking at the legal system in St. Maarten, we actually don't need all that. We don't need all that complexity, because we're translating from our own legal system to our own legal system. We just have to be careful not not to make the same mistakes that other countries did. And I'm going to go through a little list of these mistakes in about 8 minutes, I guess. But before I do that, I'm going to go through in what way can you translate, actually? What are the techniques you use? You translate depending on the purpose. Within the system, like we're talking about Dutch and English, within St. Maarten, for example, within the international context, which needs comparative studies, but then for the international organizations, or in a comparative context between countries. If you do that, SLLS is just Source Language Legal System. TLLS is Target Language Legal System. Yes? So if you have a target language that is used as a legal language in more than one legal system, the translator has to make a choice for a particular target language legal system. You have to be clear into what kind of English you're going to translate, whether you're going to translate to American English, for example, or to British English, or to St. Maarten English. Because that is going to dictate what kind of vocabulary you're going to use, and what kind of ritual phrasings you're going to use. And the choice of the target language legal system depends on the potential uses of the translation. Now, you also could bear in mind, for example, if you're going to translate in St. Maarten, that you might be translating for an audience for informative purposes. You're going to translate for the people in the street, the people in the schools, the people who are working and who just want to understand what their rights are or their obligations are. You can do that, but you have to be very clear about what you're doing at that moment, that you're not writing law. You're writing an information brochure for the people, yes? Now, the way to translate law, because you have to have functionality of the translation, is through equivalence normally. Equivalence is that you actually find equivalent terms in the target language legal system that fit your needs. If you're talking about marriage and you're translating to Dutch and you wouldn't use the word huwelijk or echt, you'd be a bit of a confusing translator, of course, because it looks most like it. And that's why you use that terminology, of course. Full equivalence only occurs if the source language and the target language relate to the same legal system. Take, for example, Switzerland. They have 4 legal languages: French, Italian, German, and Retro-Romanche. And so they have a lot of translators who are all the time translating between these different languages, but they're all equivalent terminology. I just use the example of Belgium. Belgium has Dutch and French and emerging German. And there's full equivalence between those languages. So if you do something wrong in Flanders, you'll get the same penalty in Wallonia, for example, same sanction, but it will be in another language. That's the only difference.